2012, how many meetings did you have with representatives of XYZ company to negotiate the contract at issue?
About 3.
When was the first meeting?
Mid-February.
Who attended on behalf of ABC company?
I was there, as well as Paul Delaney,
Who was there for XYZ?
Mr. Silver, and Mr. Smith.
What was the conversation?
Basically, Mr. Silver said he was really anxious to provide us with the electronic chips, and he said that his company prided itself on providing top-notch products, which obviously isn't true, or we wouldn't be here.
What did you say in response?
I said that top-notch products and, getting the best product available was very important to me.
Now, there was a meeting in February. The next meeting was in March with XYZ company, correct?
Right.
Who was at that meeting?
Same people.
Was there conversation?
Yeah.
What was said?
Basically the same thing as the first.
Dave, you were playing the defending lawyer, and you didn't say a word during this vignette.
Not a word.
What were you thinking?
Well, I was, as the defending lawyer, pleased to hear the questions as they were coming, and happy to sit there and let the lawyer ask questions just like that.
So what did you like about the questioning?
Well, again, what I liked about the questioning was its ineffectiveness, and there are probably 3 reasons why I thought it was particularly ineffective. Number one was the answers that were coming were typically general or approximate or equivocal. The witness used words like basically or about, and the questioner failed to ask follow-up to pin down the witness as to what the specific knowledge was. And later on in the courtroom, of course, the witness will be able to be more specific since specificity was not asked. Secondly, there was a failure to determine whether the answer that was given was the entire universe of information. So she would say the first thing that came to mind about a meeting, and the questioner failed to determine that that was the extent of her knowledge relating to that meeting, that there wasn't anything else that she could recall. So again, it was left open for the witness to add to that which was elicited at the deposition. And I think most important problem with the questioning is that it didn't ask summary questions that addressed the reason for the questions. So assume the reason for the questions was to determine if an agreement had been met at the meeting, whether the parties had actually reached an enforceable agreement during any of these meetings. There was no asking of that question. What the questioner should have done after all of the details of the particular meeting had been determined is ask the summary question, was there any agreement made at that meeting? And get the confirmation and admission from the witness that she couldn't recall any discussion that led to an agreement at that meeting. So general answers, failure to determine the complete universe of information, and to me, most importantly, the failure to directly ask the question that was the most important question about the meeting as to whether or not an agreement had been reached.
Lana, you were stuck with the script we wrote for you. What was your reaction?
My first reaction is, why was this deposition being taken if these are the questions you're going to ask? The clear purpose of a deposition is either to elicit information for a motion or something, or to make sure that at trial that you know everything that's going to be said by this witness, and you're going to, as was said before, close that door. And this didn't do it. And it didn't do it in a lot of respects in terms of, one, not tying down specifics when the meeting was. That could be important because there could be other discussions, other letters. So not determining whether there was any way to determine when in mid-February the meeting was. Everyone has calendars. Everyone has other documents that might indicate, was the meeting actually set up? Are there emails? All of those things could have been asked. There were a number of people at the meeting. We only know what was said by a couple of them. And there was no effort to find out what everyone said. More importantly, I don't know what the purpose of these questions are. As you said, there isn't a conclusion in terms of was there an agreement. There's no conclusion, was there any follow-up memorandum, letter, email, or anything concerning that. And to allow someone to say, well, the same things were said at the next meeting, you have to raise an issue. Well, what's the purpose of the second meeting then? Something's missing. And finally, I think that the biggest problem is letting the witness off the hook in terms of the ability to see a document at trial, to refresh his or her memory, and all of a sudden you have a complete and different story. Oh, he didn't show me this document at the deposition. Now, having seen it, let me tell you now what I recall being said. And there's just no type of a closure that you could go into court with and feel comfortable you know what they're going to say, which is the goal of a deposition, in my opinion.
I think that what we saw there was more of a conversation than an inquiry. And there was a total absence of control. As Lonnie's pointing out, there's a lot of information that wasn't obtained and a lot of points that weren't established. And the function of this type of a deposition questioning line is to learn what you need to learn and prove what you need to prove, and neither of those accomplished in this kind of a questioning.
Yeah, picking up on Dave's original comment about learning the extent of the witness's knowledge, one of the things that I try to remind myself of and tell younger lawyers, new lawyers, is that ask the question until the answer is no. So if the question is here, who attended on behalf of the ABC company, and the answer is I was there and Mr. Delaney was there, that's not the end of the Q&A on that subject. The next question is, did anybody else attend on behalf of ABC? And if the answer is, well, at some point, Mr. Johnson stopped in, that's not the end. You say again, did anybody else attend on behalf of? And sooner or later, the witness will say either no or not that I recall. Okay, you can go to the next question, and you discipline yourself the same way with the XYZ company, and this script forced Lonnie to be completely undisciplined. There was no follow-up.
And another thing is, maybe someone attended who wasn't there for either company, who might have the best memory, might have been there to take notes. Who knows? We don't know who was present at the meeting, because the questions I asked were limited to who was there for ABC and who was there for XYZ,
right,
without knowing whether there was anyone else there.
Well, for all we know, this conversation was being tape recorded. There was absolutely no inquiry about the details.
Right.
And I would add to your comment that you pursue the questioning until the last answer is no, that frequently the best last question is, do you have any further memory that can assist us, or any further memory of what occurred during this meeting? And then when you get that no for the summary conclusion question, you can move to the next issue.
You know, the way I look at it, especially with young lawyers, is sometimes you'll tell them to go research something for you. And you usually get something that's extremely detailed and covers all of the bases.
Good point.
This is very similar. You tell them, you take this deposition, I want to know everything that happened at any meeting, period. I don't care what. Give me everything. And that's what the questioner has to do.
I like that analogy a lot. The new lawyer coming out of law school knows that when doing legal research, they don't accept the first case that they come to. They don't just take the first proposition that pops up. They know that they have to pursue to find out what the actual law is. When they're taking depositions, though, they forget that kind of pursuit. They often are accepting the very first thing that comes up, as this script did.
Yeah, and there are certain basic facts about this conversation that were not even touched upon, and if you knew the answers, they would tell you something. For example, how long did the meeting last? You know, was this 10 minutes, or was it 3 hours that they were sitting there? Those are very different kinds of meetings and conversations, and they also clue you into the fact that if the witness gives very short summary answers, if they were there 3 hours, a whole lot more than that was said. There was no question about were there documents in the room, did anybody take notes, and following up on Dave's question about what was agreed to, I think with a meeting, it's very often a good idea to ask, how were things left at the end of the meeting? It's an open-ended question that invites the witness to talk, and a lot of times it tells you, well, that's what the meeting was all about. I sometimes, particularly in business litigation, and I shouldn't say sometimes, I do it regularly, I'll have a separate tout sheet on questions to ask about a meeting. So you go from this meeting to that meeting to the other meeting, and I've got my checklist there to be careful I don't get sloppy, I don't fail to ask that additional question, so that when you get out of the deposition, you don't smack your head and say, I never did ask such and such.
Or get back to the office and have the senior partner who assigned the deposition ask the basic question that you can't answer.
Right.
You have to ask the questions that are going to enable you to explain precisely the details of that meeting. And this scenario showed that this person could not get back to the office and answer important questions about what had happened.
I'm always concerned, too, that the lawyer on the other side during trial, if we get to that point, is going to be able to do something to unravel my deposition. And we're in 2012, February. We're now well over a year after that. People's memories fade. And so you need to tie down what's out there that's going to prompt the witness to remember something that he or she may not remember, because that's an easy thing to sell to a jury. Well, it's been 15, 16 months. They didn't remember. If he had shown this document, if he had explored the notes or anything, then there's some things that would have come out, which the other side will do at trial, and it's very difficult to argue, well, they should have remembered. So you have to close that door with maybe a question, even if you don't have any documents in front of you, is there anything you could look at that might help you remember things that you don't remember? Anything, maybe an internal memo, anything. It could actually be a memo from a lawyer. You're not asking them to disclose it. You're just saying, is there anything? And find out there is, because maybe there's more discovery you need to do after the deposition.
Well, let me summarize that point the way I like to describe it, and that is that the questioner is not only trying to find out what this witness knows about the events, but what this witness knows about what other information might be available to tell us what happened in these events. So you want to use the witness to exhaust the witness's knowledge, but also use the witness to lead us to other evidence. And that's exactly what you're describing here. And frequently the witness's memory will be poor, but the witness can be an excellent guide to where we can find better information about what had taken place. And of course that didn't happen in this scenario.
I think if you think about it the way law firms actually work, and that is deposition's over. You go talk to someone about it. You give them a summary of it. This meeting ended. Who did they talk to? As you said, who did they give a summary of the meeting to? And I think that's important too, because there may be, as you said, that person who says, well, this person told me A, B, and C after the meeting, and so you have to close that door too.
Following up on Dave's idea of, you want not just this witness's information and knowledge, but you want to get leads on who else would know, et cetera. I find that if you run into a witness who is very tight-lipped and doesn't know, doesn't remember, et cetera, if you say to him, well, if you wanted to get that information, what would you do? That will sometimes get what you're looking for. And a variation on that is to say, if your superior at work told you to find that information, how would you go about doing that? And the good thing about that, I think, is that people are used to taking instructions from their superiors at work. And so if that guy asks for it, well, then I would go look at this file and call that person, and pretty soon they're being very helpful instead of quite so tight-lipped.